document. The Supreme Court of India has played a pivotal role in shaping the contours of our democracy through its interpretations of constitutional provisions. The concept of judicial activism has emerged as a significant force influencing policy decisions and societal norms. Today, we seek to explore the balance between judicial activism and judicial restraint, the impact of Supreme Court's interpretations on legislative and executive actions, the evolving role of the judiciary in safeguarding fundamental rights and promoting social justice. Today, we are privileged to host a legal luminary whose scholarship and experience and contributions to the field of law are both vast and inspiring. Senior Advocate Dr. Aman Hingorani. Dr. Hingorani is a senior advocate at the Supreme Court of India with an extensive practice before the highest court, including its constitutional benches as well as various high courts across the country. His litigation experience spans a wide range of legal fields, many of which have shaped and transformed legal jurisprudence in India. He is also a trained mediator associated with the Supreme Court Mediation Center and the Delhi High Court Mediation and Conciliation Center, and an internationally accredited arbitrator with affiliations to institutions such as IDR, RMIT Melbourne, Delhi International Arbitration Center, the Indian Council of Arbitration, and more. His arbitration expertise is frequently sought even by the Delhi High Court itself. Dr. Hingorani's commitment to legal education is equally remarkable. He serves on the Executive Council of the National University of Study and Research in Law, Ranchi, and the Board of Mentors for the Executive Masters in Mediation and Conflict Resolution at Maharashtra National Law University, Mumbai. Since 1998, he has passionately trained law students, judicial officers, practicing lawyers, and law faculty members across premier institutions in India and abroad, including Oxford, Warwick, Harvard, and Yale. He has played a key role in shaping legal curricula and training materials for significant national initiatives such as the Indo British Project and Advocacy Skills, the All India Bar Examination, and the ADR manuals for PhD, CCI, and FICCI. Dr. Hingorani is also a respected author. His book, Unveiling the Kashmir Knot, is a widely discussed work and adds to his extensive portfolio of over 83 national and international publications. His insights have been sought by the Parliamentary Standing Committee on Law and Justice, Rajya Sabha, and even by the Foreign Affairs Committee of the UK Parliament, reflecting his expertise in both domestic and international legal political discourse. We are indeed fortunate to have him with us today to share his perspectives on the evolving role of the Supreme Court in constitutional interpretation, a topic as relevant as it is complex. I now request our Honorable Head of the Department, School of Law, Dr. Vivek Goyal, sir, to come and facilitate our yes. So we are truly honored to have you with us today, and we look forward to your input.
Thank you, Vinita, for that very generous introduction. So I've been talking to you after many years. So friends, Manisha mentioned two terms. So she opened up. Am I loud enough now? So, engaging purpose. So, yeah, yeah, that's better. So Manisha mentioned two terms when she was speaking, judicial activism and judicial restraint. You all are law students of varying years. What is your understanding of these terms? What is judicial activism? What is judicial restraint? And feel free to speak your mind. I mean, it's a classroom. You can't be even if you're on so what. Anyone? What do you mean by judicial activism? You have three organs of the state: parliament, executive, the judiciary. Judiciary is supposed to give effect to the laws made by parliament. In the process, they interpret laws. Common law tradition is making law. They make laws. If they're doing their job, is that judicial activism? Would anybody like to discuss what is the meaning of activism in context of the judiciary? Forget about the Supreme Court of India for a minute. Generally speaking, what do you mean by judicial activism? Yes. So, but like I said, that's interpretation. And the voices from the grave, the old scholars who say courts never make law. Courts only discover law made by parliament. But then common law itself is just made law. And in India, you have judgments of the Supreme Court which now recognize that judgments and law is not babies brought by constitutional strokes. They're actually made by judges. In DTC Corporation, the Supreme Court said we must do away with this childish fiction that the courts don't make law. Of course, we make law. And law we make is just as good statutory law is law of the land under Article 141. So judges make law. That is the job. It's a different issue. I mean, and law is politics. So judges do indulge in politics. Only the question is, what is the constitutional standard by which they can do so? But in that context, if there's judges give interpretation of law, they make law, then what do you mean by judicial activism? They can't be making law while sleeping. They will be active. So when you say active interpretation, what do you mean by active interpretation? Okay, is question on the Bharati's case, basic structure doctrine, judicial activism? Is it? Why is it judicial activism? Anyone? Is public interest litigation, PIL, judicial activism? It is. Why? Or is PIL a symbol of a broken system? That people languishing in jail for 20 years or trial. So the courts must do something to protect their rights, release them if they have been in jail for periods longer than actually been tried, convicted, with maximum sentence. Say somebody's inside for stealing cycle. He should be out in 6 months. He's there for 20 years waiting his trial. So he's got extra prison terms to his credit. System is broken down. Court says speedy trial. He must be released. Is that judicial activism or is it a symbol of a broken system? Are any of these instances of judicial activism? No response. I think there's some people nodding their head in the back. What are your views on this? Is this judicial activism? Yes. Okay. Medical Gandhi's case. How many of you have read that case? Passport was taken away without giving her an opportunity. Give post facto hearing. The procedure, no, Article 21 says no will be deprived the law because of the life and personal liberty, the procedure established by law. The procedure must be fair, just and reasonable. Is that judicial activism? Is it? Or is just a natural law school approach? If you were to study jurisprudence or positive laws, natural law school, so within the common law system, you're swinging between positive law school and natural law school. So just to take some cases, I mean, we inherited the common law system. In the common law system, the system is adversarial. There's a dispute between A and B. They find the lawyers present the case before the court, and the court decides that conflict. Within the common law system, there is natural law school and positive law school. So we started with Gopal A.K. Gopalan's case, 1950. You have studied that case. So long law is made validly, what is which is within the legislative competence of of Parliament. The quorum is complete, etc. So long law is validly made, we won't get into the fairness of that law. So if law says if you steal a loaf of bread, you'll be given death penalty. It's validly made law, we won't interfere. We're not there to see the fairness of that law. That's the wisdom of the legislature. So that's positive approach. Law gives you rights, law can take away your rights. Swinging into natural law school, Cochini's case, 1959, that fundamental rights are inherent in everyone. To get law does not give them to you, get them at birth. So they're inalienable. 1967 Golaknath's case, natural law school, fundamental rights are inherent in you. Parliament can't take them away. Swinging back to midway in Kishan Bharti's case, 1973, 6 judges say go by natural law school, 6 judges go by positivist law school. And Justice Khanna tilted the balance by going to positive natural law school but saying fundamental right to property can't be in a socialist constitution beyond amendment. But the Supreme Court was divided. Come back to positive law school in Indian General Court, emergency case, habeas corpus case. During emergency, your fundamental rights can be taken away. Your right to habeas corpus can be suspended. So again, you're shuffling into positive law school. Then you come back to Maneka Gandhi, 1978, natural law school. Are any of these cases instances of judicial activism? You're just taking a different approach within the common law system while adjudicating a dispute. And then you had PIL. What is PIL? Public interest litigation. That's a full form. What is it? Is PIL part of a common law system? Is PIL adversarial? Have you studied PIL in your constitutional law classes? So what is PIL? There was a PIL file recently that covered Josh made mandatory or something, or censorship of reference tools, or Pervez Musharraf is visiting Agra for the Agra summit. He should be asked not to come here. Or that actress Divya Bharti jumped off the top floor, just suicide or she died. We are her fan club. Please investigate. So what is PIL? Anyone? Yes. Okay, so person files a case in behalf of the entire public. So I think every woman should keep her job on filing in behalf of the entire public. Is that your legitimate PIL? Or like I said, Praveen Musharraf coming and filing in behalf of the entire public, or even by entire public, a determined class of people, fan club of that actress, was the distinctiveness of PIL. Anybody else? Does it have to be for the member of for the public at large? Google Shah's case, you was studying? Google Shah 1983. Anybody knows about that case? This person was arrested in 1953 on charges of murdering his wife, put before the sessions, acquitted by the sessions in 1968. The judge said, release him for the orders. Those orders never came. So by the time he was released, he has spent 9 years in jail for a crime he did not commit. 14 years after his acquittal. Yet just yet another symbol of a broken down system. And by the time he was released, uh, there was a case, of course, in Barbara Brandon's case was the first discussion should the Supreme Court award compensation under Article 32 in addition to civil damages. But the very first case in which was actually awarded was Google Shah, when Supreme Court gave compensation under Article 32. Normally, if you have a file for damages, you go to civil court, file a suit. But Article 32 is grid jurisdiction. So the Supreme Court granted compensation with the grid jurisdiction for the first time in Gosha's case, but that was the case of an individual, not public at large. In the process, Supreme Court gave an interpretation of his powers under Article 32. Is that judicial activism? So it's very easy to use the word judicial activism, the activist force. Is the Supreme Court, or for that matter, any court, constitutional court, which has to react to such a hard case, being judicially active? So just to give you a background, since most of you are not really willing to commit yourself by saying anything, uh, PIL is not Anglo-Saxon jurisprudence. It is not common law system. It is unique to India in the form it exists here. And that's perhaps the beauty of our constitution. We have a very beautiful constitution, a very liberal constitution. But how it translates into practice depends on the character of the men and women who are running or acting under the constitution, whether it's parliament, executive, or judicial. It's the national character that decides. And I don't think I need to spell out the national character to you. You all have suffered it. So it's the constitution by itself is a very good document. But when we are acting under the constitution, we see that you're confronted. I've talked to you about cases from 1950 to 1978. Then came the Mr. Khatun's case, the first PIL case, which related to people languishing in prison for no crime other than the poverty for periods longer than had they been tried and convicted and given absent sentence. Now, this came out in press reports, read by a lawyer couple in the Supreme Court, who said we must move the Supreme Court to do something about it. The registry said, who are you? They're not your clients. You don't have a wakalat now. These are press reports. How can you file a writ petition? But under without elections, they listed the matter listed for the court. And the Supreme Court issued notice. Reasons why they issued notice will be available. There's a whole backdrop of emergency, the courts losing, every institution of the country losing credibility during the emergency, including the courts because of 1872. There's been a political vacuum, and many scholars say the Supreme Court wanted to um, fill in that political vacuum. But whatever may be the reason, notice was issued. About 40,000 people were released in about 6 months, and many more later on. Now, if you think about it, this was a case brought on the basis of press reports on behalf of people who had no access to books. A fallout or another offshoot of the case was the Balpur banding case, where 33 suspected criminals were taken in custody to contain crime and to teach them a lesson. They were blinded by the police in police custody using the bicycle spokes were poked into the eyes, acid was poured onto the eyes, water was taken soaked with acid, and that was bandaged on the eyes. The state gave these police officers planetary awards for containing crime. And eventually, when the matter came to Supreme Court, this was effectively the third PIO. The second one was related to accumulation of suit with slate pencils in the Mysore district in Uttar Pradesh, where children were dying at a young age. But this was the third PIL where the Supreme Court laid down that you must have legal aid, estate expenses, and so on and so forth, watched all this, the trials, gave lifelong pension, order rehabilitation, and all that. But again, this was a case where again it was brought by people who did not have, on behalf of people who did not have access to courts. Common law system A has a problem with B. There's a dispute, there's a conflict. In these cases, there is no conflict. You can't keep people in jail for 20 years of trial. You can't blind people in custody. So there's no dispute. So the Supreme Court is not adjudicating, there's nothing to adjudicate. So PIL is a remedial jurisprudence by which the Supreme Court tries to protect the rights of those who do not have access to the courts. So broadly formulated, if you see Article 32, the right to move the Supreme Court is guaranteed. The argument by the lawyer couple was Article 32 does not say who will move the Supreme Court. It does not say how you will move the Supreme Court. All it says is that the Supreme Court is under a constitutional obligation to protect fundamental rights. We as officers of the court are bringing to your notice that these people's fundamental rights are violated. You do your job of protecting the fundamental rights. So the Constitution of India does not permit PIO, but the language of Article 32 is wide enough so that it does not prohibit PIO. And that's how this whole jurisprudence started, where the Supreme Court confronted these cases, accepted these petitions, saying that any member of the public can move before Supreme Court or the High Court under Article 26, acting pro bono, bona fide, on behalf of any person or section of people who, because of some disability, whether illiteracy, poverty, mental illness, cannot have access to courts. Because of this remedial nature, there are many features of the common law system which gets altered. Because it's remedial, it hardly makes a difference who comes to court for local standards release. Because it is remedial, it is not, it's non-adversarial, it's collaborative. It is investigative. The Supreme Court sent its registrar to Bhagalpur to find out whether these people were blinded. Because it is remedial, the petitioners are not required to prove the facts. The court can set up fact-finding bodies like in Doon Valley case and many other cases. Because it is remedial, there's procedural flexibility. A telex can trigger off the judicial process. A telegram can set up the judicial process. Because it's remedial, doctrines of res judicata latches do not apply. With procedural flexibility in the forms of you don't really need to rely on legally admissible evidence. A huge number of differences from the common law systems. Because it is remedial, the courts can have an active role. And here's what the catch comes. The common law system, the way it is devised, has certain checks and balances on the judge and the litigant. As far as the judge is concerned, the idea of having a third person decide the conflict between A and B means that that third person has a lot of power. The third person must follow certain standards. You can't act arbitrarily. You cannot act subjectively. Every person has their own prejudices, their own conditioning. So there must be a standard. And so under the common law system, the standard is laid down by saying there should be a level playing field. The judge can act only on the basis of pleadings. The judge can act only on the basis of evidence on the issues which arise from those pleadings. So the judge cannot go beyond the pleadings, cannot go beyond what is before the court. So there is a particular checks and balance on the judge. There's checks and balance on the litigant. You need you need to be effective. You need to be the lead party to start the process. You can't be a busybody. You need to file the case in a proper format. You need to produce legally admissible evidence. These are checks and balances of the common law system on the judge and the lawyer and the litigant. Now, these checks and balances are removed in a PIA. The judge can do whatever the judge wants to do because it's not adjudication in the first place. So that brings in the issue of subjective exercise of power, and hence arbitrary exercise of power. We'll come to that in a bit. And similarly, because the checks and balances of the litigant is also removed, any member of the public can remove the court. So far, it is for the poor and the disadvantaged and the marginalized. Nothing, it doesn't really alter the position. There's no real danger of anything happening. But then came a second kind of PIL, if you recall it. S.P. Gupta's case, 1981, where the Supreme Court expanded the scope of PIL to not only to include cases which are diffuse, metaphysical, collective rights, rule of law, corruption, environment, which affects everybody. Now think about it, where the cases are for the poor. If you go to the checks and balances, the courts can't do much damage. But where cases are related to diffuse and collective rights, there can be a conflict. And the court, by bringing them in as a PIL, are acting without the checks and balance on the judge. In Doon Valley case, I'm sure you read that case, there was competing interest between development, employment, there was the environment, defense, was limestone was required. There was a conflict. The court is acting in a PIL minus the checks and balance of the common law system, which means every judge can act subjectively. It's not a question of malafide or dishonesty. But a person may think differently. So every judge will act subjectively, and hence there will be an arbitrary judicial process. And that is what precisely happened. The Supreme Court expanded the scope of PIL to include, in the first phase, governmental issues, then environmental issues, and in that, they what the executive is saying, you it will give the creeping jurisdiction of the Supreme Court. You creep into areas of executive legislature and take away their functions, minus the checks and balance on the court, which brings the issue of accountability about which we'll talk. So that is PIL. Now this is judicial activism. Judicial restraint was limits of the law. It's not our job. But is this judicial activism, or as the executive would say, a power grabbing strategy? These kind of cases also open the doors for unscrupulous litigants. And so A files a complaint or petition saying B, a rival industrialist, is discharging effluents in the river. Later on, the court finds out that A and B are rivals. So there's a backlash. Court start realizing with this misuse of PLO. And so in Bulbul Shopper's case, 2010, Supreme Court laid out certain guidelines, which said that now it's high time we need to have these rules, PIL rules, or High Court should frame them. The judges should prima facie be satisfied that there is what the locus of the person who's being in the case, credentials of that person. And the court should be prima facie satisfied about the merit or the content of the allegations. The Supreme Court did not clarify whether this is applicable to every kind of PIL case. So Supreme Court said there are three different stages of PIL. First stage was for the marginalized, second environmental law, third governance issues. And then the High Court framed the rules. Supreme Court is what its rules. And now what do these rules say? The court have to be prima facie satisfied about the credentials of the petitioner and about the content of the petition. So if today I see bonded labor, I will be going to the court and first establish the court why I'm coming to the court. I'll have to give my Aadhaar card. I will have to give undertaking that this is that if there is no merit, I'm willing to pay security or cost. Why on earth would I want to be entangled with the state? I won't file the case. I won't go around, but I don't want to be under scrutiny. The purpose of PIL is to tell the court to do your job of protecting fundamental rights. The Supreme Court has shifted the focus on the petitioner establishing his credentials why he's coming before. And then prima facie merit of the case, the first case started with press reports. Now, if you go to a court and you file a case at press report, you will be saddled with cost of 1 lakh rupees. So, is PIL again the first question I asked you? Is it judicial activism? What has happened in the country is that we inherited a colonial structure, we inherited common law system, but there's a definition of a court. A court is supposed to be a place where a conflict is decided. If there are cases where if a court can't decide a conflict for, say, one generation, two generations, we need to revisit definition of the court. Delays, all that apart. In other countries where there were delays, they went into ADR, mediation, arbitration, etc. We try to reform our system from within. In Lesbia's case, the Supreme Court talks about saying we must use laws instead of distributive justice. We can't be we can't be neutral, we have to be pro, etc. And whatever's held in PL case becomes law the land by virtue of Article 141 and permeates every branch of law. So far, so good. But what is in the process, what has happened is whenever there is a hard case, the court responds to that to add an element to this jurisprudence of PIL. Say reactive jurisprudence. But that jurisprudence, which started off for the poor, has been hijacked by middle class interests, CNG buses, and no smoking in public places. Those kind of cases, as opposed to cases for the poor. No, those kind of cases, I mean, I should not be it's true to say that these cases are not important. They are important. But the same wonderful judgments could have been given as class actions under Order 1 of the CPC. In other countries, for public interest matters, they are class actions. One member of the class acts on behalf of the entire class. It's within the common law system. If there's environment pollution, even my life is being I'm being deprived of my life minute by minute, bit by bit. I'm also affected. I can file a class action to say there's environment pollution. The very distinctiveness of Indian PIL is you should not have a person stake in the matter. So these cases could well have been filed as class action within the common law system, complete with the checks and balances on the court and the litigant. But the politics of this is that what could have been litigated as class action has been brought in the scope of PIL minus the checks and balances on the judge so that it is the power gets concentrated in the judicial. That has broader implications. You would have read in your constitutional law classes that can you file a writ against the court? Article 12 defines state. The Supreme Court said, of course, if they be in order for rules violate a fundamental right, that can be struck down. But in Naresh Rashtra's case, 1966, the Supreme Court of the view that a judicial decision can never violate a fundamental law. Because what are we doing? We're only adjudicating. But in a PIL, they're not only adjudicated. There is no adjudication. In a PIL, a court can get into policy matters. One of the earliest policy cases was that of Kanga way back in 1980, which talked about dowry crimes. And in those days, there used to be kerosene stoves, which suddenly burst, and the newlywed brides used to catch fire in the dowry deaths. So the police was acting with the patronage of the husbands. So the Supreme Court, when the PR was filed, talked about reforms, and then there were the crime minister cells set up. Branching mental asylum, Agra, Gwalior, patients were dying on a daily basis. There were no medicines, no electricity, no doctors, no treatment, no food, no water, no clothes. There were no windows, there was just gaping holes. So these patients were tied naked, were changed naked to the beds. It was the Supreme Court which started administering the hospital, started fixing diet money of 10 rupees per patient. Eventually set up a committee, the Patna High Court was asked to take over, that didn't work out, set up a committee. When the Supreme Court formulated, made these hospitals autonomous, formulated their memorandum, told the state, publish this in the official gazette. The Supreme Court legislated the way it legislated in Vishaka's case, in the foreign adoptions, Lakshmikant Pandey's case, where there's no law, Supreme Court legislates and Parliament steps in. So the Supreme Court can legislate, Supreme Court can lay down policy, which you can't do in a common law system. But you can do that in a PIL to the extent it's necessary to protect fundamental rights. But that's what the mandate of Article 32. So when the Supreme Court is carrying out an investigative function, it is administrative function, this law-making function, it's not adjudicating. Can a writ be filed then against the Supreme Court for violating of fundamental rights when it's carrying out, say, its administrative function? of administering a hospital. So the whole case law which is taught in law schools actually breaks down because the Supreme Court is not adjudicating. The rationale of Narendra Rashtra's case was that you're only adjudicating Justice Gaikwad had taken a point of view saying, of course, courts can violate fundamental rights. What if I'm holding court and I say, you're a member of this community? I don't want members of this community to sit in my courtroom. Am I not violating the fundamental right? ATM Jabalpur's case was violation of fundamental right in 2010. In Nambiyo's case, Supreme Court itself said, yes, ATM Jabalpur's case violated fundamental rights. So if a judicial decision can violate a fundamental right, how about making the courts accountable for filing writs against them? So so that was the argument. That was something which I've written way back in 90s that you must be able to file writs against the courts. But then came Rupa Hura's case in 2002, which actually even before that, if you see Justice Thomas's views in Kishore Bharti's case, Justice Thomas went on to say that judiciary is state under Article 12, even for its judicial active cases. Then you had other decision, 1975. The several decisions where the Supreme Court expanded this view to say judiciary is state in exercise function. Um, in Rupa Hora's case, all these judgments were overlooked, relying in Narendra Rash's case, where the Supreme Court said that yes, we are human, we can make mistakes, and so the remedy would be a curative petition. And what is a curative petition? Anybody? You have heard of this word curative petition? What is it? Anybody like to guess? So basically, what's this? Somebody was saying something? A bit louder. We heard the case. We judge the case. Well, that's ostensibly, if that's what they say, but let's see what it says. What the judgment actually talks about. Now, as you know, you can file SLP, rates, etc. The decision by the Supreme Court. Now, what makes it, then if you don't like the decision, you can file a review under Article 137. Now, the Supreme Court has framed its rules under Article 145 to say these review petitions will be decided in chambers by circulation. So there's no open court hearing. So effectively, that means, that itself dilutes that particular right of review. Then the Supreme Court goes on to say that suppose somebody has filed SLP, filed review, they're still not satisfied, they can file a curative petition which will go to 5 judges. But amongst those 5 judges will be the same bench that dismissed or passed the orders in SLP and review. And this review petition will be filed only in grounds of miscarriage of justice, very limited grounds, accompanied by a certificate of a designated senior advocate saying there's merit in it. So the basic principle of law, you can't be a judge of your own case. How can the curative bench have members who are part of the bench against whose orders your opinion? It's against common sense. And then you need a certificate of designated lawyer who will charge huge amount of money for giving that certificate. So it's illusionary. But that is the remedy offered by the Supreme Court. It's not there in the Constitution. It's not judicial activism by any stretch of imagination. It's a remedy offered by the Supreme Court, which is not there in the Constitution, just as the collegiate system is not there in the Constitution, to say when we make a mistake, this is your remedy, as opposed to a writs against them. Couple this with generous contempt of jurisdiction of the Supreme Court. If you don't like something, contempt notice. Couple this with another branch of law which has been laid down by the Supreme Court. In 1996, there was a case of DC Saxena, uh, where the court made certain observations which said that day in, day out, writ petitions are filed, SLPs are filed, and we dismiss them without giving reasons. That's the practice of this court. And we don't need to give reasons because we're the highest court. A writ petition is a guaranteed fundamental right. What apparently the court overlooked is the requirement of giving reasons is to keep the judge in check. He must justify the views taken. A judicial decision is known to be one because it's supported by reasons. If you don't give reasons, how would the litigant know what ground the case was allowed or rejected? So the Supreme Court said we don't need to give reasons. If they don't need to give reasons, what's the purpose of filing review or curative? There are no reasons. More so in Article 32 petitions. Article 32 is a guaranteed fundamental right. It's a vested right. Article 226 is not a guaranteed fundamental right. Now, yet another branch of law had started. In Ramesh Thapur's case, if you study that case, 1950 full bench Supreme Court, they said the right to move to the Supreme Court is a guaranteed fundamental right. Supreme Court cannot throw out that petition if there's allegation of or apprehension of a violation of fundamental right. In Kuchini's case, 1959, a constitutional bench of the Supreme Court again laid down that even if they disputed facts, the Supreme Court must record evidence of it by affidavits and nothing else, but they cannot throw out the petition saying there's an alternative remedy for the High Court. So the fact that the High Court has an alternative remedy under Article 226 is not a ground of throwing out a petition under Article 34, according to the full bench of the Supreme Court. Then in 1987-88, there were two decisions by two judges of the Supreme Court, the division bench, two judge benches, P.N. Kumar's and Bramble's case, which said, why should a lawyer bypass, why should litigant bypass the High Court? High Court has got good judges, High Court has got good lawyers. So where relief can be given by the High Court, don't come to us, go straight to the High Court first. So these are two division bench judgments. The judgments authored by two judges, contrary to the full bench. But the practice which has been evolved in the Supreme Court from at least that period, mid 1980s till 2025, is if you can get your relief from the High Court, don't come to the Supreme Court. And that, in my view, is nothing but application of the constitutional function in Article 32. How can you tell a litigant who has a fundamental right to come to the Supreme Court that you should go to the High Court because there are good judges in the High Court and avail services of the good lawyers? That's hardly a ground for not exercising your own constitutional obligation in Article 32. So when we talk about, so you see the whole picture. Expanding judicial review through basic structure doctrine. Basic structure doctrine is we vaguely define illustrations given in the Bharti's case. Suppose the government does something the court does not like, take out the stick of basic and says we struck it down. So we started off with the tussle between the executive and the judiciary when Nehru thought that executive should have primacy over judiciary. So there are a lot of relying of the parliament because we inherited the parliamentary system. In UK, parliament is supreme, and the courts were very reluctant to strike down laws. In India, it's a written constitution, it's a controlled constitution, where you have instituted judiciary having extensive control over parliament and executive. So it's different in the UK, but the initial land reforms acts, etc., suggest that the executive felt that the courts should be acting in a very more in judicial restraint within the limits of the law. There was that tussle which was going on. It was also evident in the Privy Purses case, 1971. The judiciary and the executive have traditionally been tussled, but through basic structure doctrine, the court took away the prerogative of saying what is the basic feature of the constitution. Through PIL, they filled up the political vacuum of trying to actually govern the country indirectly, non-elected judges, coupled with contempt powers, coupled with not giving reasons. So you have a very powerful judiciary, perhaps the most powerful in the world. It has done good work. No other litigative strategy is given like PIL. No other litigative strategy is given really to millions of people at the doorsteps. But that does not take away from the fact that there is a need of judicial accountability, etc. But that's another debate. But when we're talking about judicial activism and judicial restraint, when we're talking about the courts protecting the constitution, I would want you to put this in context. What was the prevailing context in the country? What was the reasons why the court took action? Every constitution has provisions across the world which says the court must protect fundamental rights or to pass orders which are just. Why did the Supreme Court act in PIL matters? So the reason behind it, there's a context behind it. So when you read your books, you read your case laws, please don't read them as Bible. A lot of facts are there which are there to support the view of the judge. A lot of facts may have been missed out because they went in. Whenever you read a judgment, you need to see that in the context of what was going on in the country. Laws dynamic, laws growing, constitution is growing. There's nothing called judicial activism in my view. The courts are basically reacting to a situation depending on the mindset of a particular judge. In court, laws only about 40-50%. The rest of it is all the political philosophy or the thought process of a particular bench. Bench A may say something, a court bench may think a different way. It is that subjective. So there's nothing certain about the kind of judgments which you have been reading and the way they teach in law schools. I mean, like, according to me, law should be taught in a very different way than the way it is taught. You need to see the evolution of law, not what happened in a particular case. So that is broadly speaking the traditional notion of limits of the law. Court should not legislate. Court should not. The court should refer to the executive and parliament. Is outgrown in a way, more so in this country, where the courts through PIL, particularly, have assumed a role other than adjudication. It can be a monitor, investigator, an ombudsman, an administrator, policymaker, lawmaker. And it is in that context one must ask these questions of judicial activism. So I'll stop here since I'm conscious of the time. Any questions, any doubts, observations, like me to explain something? There are many facets I haven't talked about, where I feel the courts have done very well or where I feel the courts could have done better. Um, More so when we talk about PIL, whether we need to revisit PIL, because if you think of the COVID pandemic, it took about 7-8 PILs for the court to acknowledge that there's a problem in the street. And these workers were working for miles and kilometers on the road. First time we saw those scenes after partition. And the courts were saying there's no problem. though they had the time to pass judgments at the same time about electrifying gardens in some state. This shows the misplaced priorities. The reason being because the instrument of PL was implanted by the courts themselves by expanding it the way they have. So there are many issues. On the whole, we have a judiciary which is still working. It's the only institution in this country that actually works. And we need that judiciary to insulate us from the police and the other people who can threaten civil liberties. So we need to have a very strong judiciary. And judiciary has stepped in a lot of times. But then there are many structural things in the judiciary, in my view, which need to be changed so that there's more accountability um, as far as that institution is concerned. Any questions? Yes. Abdul, so do you have a mic or something? Should we have a mic? It's okay. The mic will be easier than having a one. Yeah.
Sir, as for the changing political and social climate of India, what do you say is the future of that judicial activism?
You see, the thing is that, like I said, those structural changes, the way I would say is that on the whole, we must put in place mechanisms which address the apprehensions of people, like a regional system. We have all read about it. It's okay. People get people, not people who are necessarily meritorious who may or may not be brought, elevated, etc. It would be you scratch my back, I scratch your back. The apprehension. So you need to have systems which, and we don't know. I mean, it's whether the apprehensions are correct or not. All this okay. The credibility of the court lies in the eyes of the people. If people support the court, then no executive or parliament can muzzle the court. If the courts lose their credibility, then you'll have this executive coming, taking the forefront. And with them, there will be no accountability for the executive. So it's very important for the courts to be there. For that, I feel when talking about the political system, etc., we must have mechanisms in place for the courts to ensure that there is no apprehension in anybody's mind that that the courts are doing their job fairly and properly. If that does not happen, then I don't see much future for the court. The courts will lose credibility, and if you see in the past, the only checks and balance on the courts, I mean, the way checks and balance the court has been to the people. You've seen the cases of, say, V. Ramaswamy's corruption scandal when that happened, when the lawyers started telling, so you want, this person was, the parliamentary committee find, which found out that he was guilty of misdemeanor and he could not be impeached because there was no sufficient political votes. It was the lawyers who said, we want to quit it report, step down. The media took out articles. Press reports were there that he should step down and he to resign. So it is actually the people which are the watchdog over the judiciary. The people must be assured that they're protecting the right institution. And for that, the courts must put this house in order. That's my view of it. Otherwise, I don't think that they will be very genuine in the broader scheme of things if they lose the credibility. That's right. And then you have comments in the front. All I heard is that you're from Borelli. Yes.
Development, flyovers are being built. So now the flyovers are at the same level. And then I have seen it in my city that due to this, various types
People get hurt because of trying to get the Chinese thing. Like we have seen report your own child can force as things. So like this will also come like if someone also find a parent for the same, and it's also come.
And why not? But you say that one rule of PIL is if a person who can approach a court doesn't choose not to approach a court, nobody else on their behalf can go to the court. So if they are victims who can, their family members can approach the court, they can seek damages, etc., then you can't file a PL on their behalf. But if they are, but if you see, or so so that is one aspect of the matter. The other is being able to locate it. If you are locating it, so you can't locate this in the first section of PILs to talk about marginalized, etc. Because if they can go to court, they'll go to court on their own. The expanded scope of PIL, which talks about governance issues, if you can locate it there by saying that there should be a government policy on that, until there's a government policy is put in place, let the courts frame some guidelines, the way they're doing for banning of firecrackers, etc. They're removing the health hazard. So the government should have a policy. If they have a policy, is it based on relevant considerations? If they don't have a policy, the court should step in and set certain guidelines till policy set up. So in the expanded scope of PIL, you're probably located in the governance category. So there you can file a PIL perhaps in the High Court. You got that? No, okay.
कि जैसे अभी बहुत सारे इंक्रीजिंग कंसर्न्स उठ रहे हैं कि ये मिसयूज होता है पीआईएल का और पॉलिटिकल और पर्सनल केस सर आपके एक्सपीरियंस से आप क्या सजेस्ट करते हैं कि मेजर्स बहुत फायदेमंद होंगे उसको रोकने के?
See, according to me, the best way of doing that is to confine PIL cases only to the first category of cases, that is for the court. Nobody files cases for publicity when they're talking about the courts. It's only with power projects, infrastructure projects, then the whole issue of publicity comes in. So if you confine PIL only to those category of cases, all these problems will go away of misuse of PIL. PIL was created for the poor. It was not created for looking after animals in the zoo or for stray cattle on roads. These are municipal issues for which there's different remedies. So if you again take a step back and confine PIL only for those category of cases, that is the best way forward, but it will never happen because it will mean the courts giving back its political power to the government. Now the courts have taken this political power from the government through environmental issues, through government governance issues. So I don't see any court give it back. So it's not going to happen. So till that time, the only thing you can probably do is to keep increase the amount of cost for obviously misconceived PIL or where there's misuse of PIL where people are filing for political reasons or private public motives, etc. But again, that would assume that the courts are acting. There's a judicially manageable standard by which the courts are acting. They're not subjective exercise of power. The way we see it, if you go to different high courts, different benches, one court may say this is legitimate PIL, another bench may say it's not legitimate PIL. So there's no judicially manageable standards, and that is what happens when you remove the common law system checks from PIL. So the short answer is revisit PIL to make it only for the court, though I don't think that's going to happen.
That's it. Thanks.
What courts have taken?
Seven weeks now. But
Well, you see the situation is if you see the initial cases, um, it was a catch-22 situation. Now, suppose there's a violation of fundamental rights, and the court is telling the government, you're supposed, this is your job, you can't do it, we are only insisting you in doing your own job. So the government is caught in a catch-22 situation. If they accept what the court is saying, they say, yes, we are incompetent. And if they refute what the court is saying to show, it will seem as though they are justifying lawlessness. So either way, they were caught in a situation. So it started with that. And slowly, the court has expanded its scope. So I would say there is a judicial overreach in many cases. You go and see movies, there's a national anthem, they said you must play. Supreme Court has laid that down. Whose fundamental right was involved? Article 32 should be filed only for protecting fundamental rights. What fundamental right was involved? So, out of respect for the national anthem, we every stands up, nobody questions. Now, that's the instance of the judicial overreach. We are not sure whether it is laudable or not, whether we should, will it build up national pride or not, those are different issues. But was the court the right body? Did the court have the jurisdiction under Article 32 to pass such a direction? So when you have the courts which are supposed to uphold the law acting beyond the jurisdiction, I mean, the cases about working conditions of subordinate judiciary, whose fundamental right is involved? So what you should be doing in universities, do a kind of you go through all the cases you see, even if you can trace some fundamental right of your arbitrary allotment of petrol pumps, Article 14, a Wala transaction destroys the economy, but I don't know which fundamental right is involved. Take out one by one those cases, take out each case and see where the courts have intervened. See if there is a fundamental right involved. If it is pledged to it, because only standard is the constitution. The constitution says you can do whatever you want to do to protect fundamental rights. So the five writs, habeas corpus, manibus, certiorari, the prohibitions, quo warranto, and any other writs in the nature of these five writs, you have the power to do whatever you want to do, lay down policy, make law, whatever you need to do to protect fundamental rights. But only to protect fundamental rights. If there is no fundamental right, it's a clear case of judicial overreach. And that's why I feel in this country we must have judicial audits. Every judgment of the Superior Court must be critiqued. If it's a good judgment, praise it. If it's a bad judgment, hear the judgment apart, not the judge, the judgment apart. Here, unfortunately, we start attacking judges, which is not fair. Because the judges may be acting, they may genuinely believing in what they're writing. So you need to bring out the problem in the judgments. But we don't have that culture in this country. Nobody talks about it. Any other question? Any comments, any observations? Something you feel you could relate to or something you disagree with?
As you mentioned that in case of guidance, judges do act in an arbitrary manner because there is no system of check and balance. So how can we ensure that judges do not act in such a manner to take this?
See, it's human nature. Everybody thinks differently. It's not that a judge is acting malified or with a ulterior motive or is being dishonest. He or she may genuinely feel in a particular way. Because they think differently, their decisions are bound to be subjective. Because they're subjective, they're arbitrary. So one does not, that's the kind of structural change in which you're talking about. So the minute you see, traditionally, the separation of powers, executive, legislature, judicial, the idea is each act within the sphere of their jurisdiction. We don't have a strict separation of powers, but we have sufficient differentiation of what judicial power is. That judicial power is, we so far have civil law system and the common law system. They have their own checks and balances. Now, if you're deviating from that as a response to a hard case like under trial prisoners or barber blinding, sort of mental silent case, etc., then to that extent, they can't, even if it's subjective exercise of power, some judges may give a pension of 1,000 rupees, some may give a 5,000 rupees. That could be subjective exercise of power, but it can't do much damage to the institution because you're still trying to protect the fundamental rights, or you protect it may vary from judge to judge. But the minute you go beyond cases where there's no dispute, here there's no dispute, so there's no problem. But if you go to cases where there is a dispute, and there you start acting subjectively, your whole system breaks down. And that's the reason, that's precisely what is happening. So there's no way on earth, the very purpose of keeping those judicial manageable standards was the checks and balance of the common law system. By removing those, there is no the checks and balance system. So who's caught or caught as being arbitrary? So you see these judgments which come out from various high courts and the Supreme Court taking so motor notice. Why is this happening? Because there is no standard by which a judge is being asked to judge. He or she can judge as per their own notions. Okay. Any other question? Yeah, sure.
So if you look at debt collection, but there have been so many guidance kind of that and really guidelines given by court, but still not good is happening to it. Yet what should be blamed for this?
Well, you see, the thing is that at one level, yes, PIL has been effective, but at another level, courts are not the best institutions to carry out governance. Even if you think about bonded labor, court can say release them. Or who's going to rehabilitate them? In Doon Valley case, there were studies later on which said that after the quarries were closed, the employers virtually chased away all the workers there, not pay them their benefits, etc. Threw them out. The reason why we go to court is because executive has failed, you have more criminals in parliament than outside, so you start feeling parliament is not doing its job, executive not doing its job. As a last resort, you go to court. So that's the reason why we're forced to go to court for some relief. And that's the only institution that actually works in the country, or was working until recently. At least that's only earlier, the whole administration was in a way paralyzed. So you you don't have a choice but to go to court. But having said that, they are not the best forum. They don't have the money. They don't control the purse or the sword. They can just give directions which remain on paper, which are then reduced to speeches. So who's going to implement them? Nobody follows those speech directions. We started an untrial prisoners case in 1979. There were about 70, more than 70 plus under trial percentage were untrial prisoners. We see the current status in 2025. We still have 70 plus under trial prisoner population. So the more directions are there, they're only on paper. So the point is that for implementation, the court still has to depend on the executive and legislature. So policy is made by executive, laws made by the member of parliament. The Supreme Court can do what it can do, but there are limits to what Supreme Court can do. So that's the reason I don't really see the pollution go away by Supreme Court directions. And of course, there's the other aspect of fundamental duties. Despite all these bans, we still have firecrackers going on the Bali night. I mean, that's the day when it's maximum pollution. After the edition, it goes on towards the right till morning. Early morning, the firecrackers are going on. So with people, and I mean, you have to also take people along with you. You have to go, public opinion has more force than law. Law will never persuade because it threatens. People need to understand and follow that law. So, and that education, that rights and change can come only from the executive, not from the courts. So that's the reason again, it has to be the courts need to know what it's doing, which is, like I said, our courts have done a wonderful job in many areas. It's not all black. They've done an excellent job in many areas. But there are certain structural changes that are very, very necessary before courts start losing the credibility. Uh, any other question? Yes. Percent that if you see something going wrong, shoot off a letter to the now what every high court has a PIL cell where they will receive all letters, telegrams, or any kind of presentations. Then there's a screening committee which then screens them for civil court. So wherever you feel, I mean, I want to encourage you to go and file a PIL if you in the PIL is also a petition. It's under the jurisdiction. So every high court has their own rules. If you take that route, you will first have established credentials right in tangle with the state. So if you want to, or you feel strongly about something, do your research, get your data, so that is not thrown out as being without those vague allegations. Whatever is in particular things you have, whatever evidence you have, put it in a letter form, send it off to the High Court, to the PIL cell, or address it to the High Court, to the Registrar High Court. Let it go there, let it go to the cell. If the court feels they should, they need to take action, they'll take action on it. So PIL is accessible to everybody. Anybody can file, but that's a different issue of how many courts will actually act on it. The purpose of PIL is based on the obligation to students. They have the notion of studying jurisprudence. Western jurisprudence is based on rights. I have a right. So you do this. This is the remedy. So where is the right is the remedy. That actually breaks down in a PIL. This correlation. There was this case of you must have read Olga Tellis case, Bombay payment dwellers, fundamental right of livelihood. What is the remedy given by the court? Forget all the speeches and big wording, high sounding words in the judgments. What was the complete remedy given? None. You have a fundamental right of livelihood, but you'll be given a prior warning before eviction. Another case was that of leprosy afflicted persons in Delhi. They had encroached to make the jugis on government land. They were sought to be evicted. The Supreme Court stepped in and told the government, even if the encroachers, they are disadvantaged social society, first give them alternative accommodation, then throw them out. So no right but a remedy. So this Western concept of where the right is a remedy breaks down in PIL. PIL is based on the notions of obligation, not rights. It is the obligation of the court to protect fundamental rights of the people. That is the basis of PIL, not the right of anybody. And so a petitioner is not dominus litis. In a case, the petitioner is the one who decides how to drive that case, or the plaintiff decides how to drive that case. But if I file a PIL, I can't withdraw it. Court may say, you go, we'll continue the case. So the whole concept of PIL is different. And it is accessible to everyone.
Certain cases, we can see that if judiciary has overstepped its boundary in the case of deciding a PIL, then what can be the legal recourse system where we take it?
That's the issue of accountability. How do you make unelected judges accountable for taking decisions when they are exceeding the jurisdiction? Which is the reason for trial courts you have the high court supervisory judges are there. For high courts, they still want to be elevated or they still feel that through the Supreme Court you at least have a remedy. For Supreme Court, like I said, they say we don't need to give reasons for taking a view we have taken. And if there's something which you think we made a mistake, your remedy is curative, which according to me is illusionary. So there is no remedy apart from public opinion. So where you feel that the courts have done something wrong, only way is putting it in the court of the public to say, well, this is what's happening. Which is one reason, which was the argument also for the the telecasting this live streaming of the court proceedings. People are entitled to know the justice which is being dispensed, the quality of justice which is being dispensed in the name. That these are our judges, this is the argument, this is the quality of justice. So maybe that is one way of bringing about accountability. Also, as putting things in the public domain. Any other question? Yeah, for this.
What an intellectually stimulating and thought provoking session this has been. Senior advocate Dr. Aman Hingorani has provided us with a deep dive into the complex and evolving role of the Supreme Court. His insightful analysis of judicial activism, landmark cases, and the intricate balance between the judiciary and the other branches of government has given us much to reflect upon. Sir, on behalf of the School of Law, Rafigera Hill University, and everyone present here, both in person and online, we express our deepest gratitude to you. Your scholarship, dedication to legal education, and invaluable contribution to this discussion have truly enriched us. Thank you for taking the time from your demanding schedule to be here with us today. As we move forward, it is now my privilege to invite our head of the School of Law, Dr. Vivek Goyal, to share his thoughts and reflections. So,
Very good afternoon to all the students and special thanks, special afternoon, whatever I may say to our beloved Dr. Aman Hingorani sir. Uh, One thing that all of you are not aware that I used to be a student of sir, so it's my pleasure to again listen to his words of wisdom probably after 10 years. So it's my great privilege. I did not imagine that I would get this opportunity at this juncture. So special thanks to the organizing team as well as sir to take time out of his schedule and be here physically because originally we were trying to get his time for our online session, but sir was kind enough to be here in physical mode and personally. So thanks a lot, sir. I don't think so. You can find too many better speakers, too many better learned people to talk about such an important topic, be it PIL or about judicial activism. Sir has very, skillfully taken us on this journey of evolution of law that I talked about, starting from Keshav and Bharti to all the recent cases. He very, tactfully talked about the balance between judicial activism as well as judicial overreach. Um, we all discuss the concepts in classes, but again, it's not every day that you get to hear about all these things from the person who is not only preaching but also practicing. Because this is one of the major critique that we get to hear and get to feel about the academia, that there is a disconnect between the academia and bar and bench and all those things. So that is why we tend to call such learned personalities so that they can share their experience and their knowledge with you people. And I'm pretty sure that all of you must have got a lot of learnings from today's session and that you will look to implement in your future career. Um, so we tend to feel that, as you very correctly talked about, that there is a lot of subjectivity. I think once judicial activism is other person judicial overreach, we have seen judges taking this, call at times and disposing such PAs, calling them, um, say, scrupulous at times as well, and malicious at times. But otherwise, again, as rightly pointed out, other high courts dealing with them and providing relief to them as well. So there needs to be some judicial standards over which such decisions can be judged upon. Thanks again, sir, for pointing out all these things. We are sure that all of these lessons and learnings are going to prove very useful in our future careers. So thanks a lot, sir. Thanks a lot, sir. All right.
thank you, sir. As we continue with the Vidhisattva lecture series, I encourage each of you to reflect on the insights gained today and to remain active participants in conversations about constitutional law and governance. With that, before we conclude this session, thank you once again, Dr. Hingorani, and thank you all for being a part of this enriching discourse. Wishing you all a very wonderful day ahead.
Okay.